Welcome to People's Law School. This segment is about DUI, driving under the influence of alcohol, a criminal charge in the state of Kentucky. My name is Len Ogden, and I have with me today Emily Roark. Emily, would you introduce yourself and give a little background about your education and your present practice here in Paducah?
Sure. My name is Emily Roark, as Mr. Ogden just said. I practice here with the Bryant Law Center. I've been practicing here in Paducah for about 8 years now. I went to Center College in Danville, Kentucky, and graduated from the University of Kentucky Law School. And I primarily practice almost solely in criminal defense work and do a lot of DUI work as well.
And I handle personal injury for the plaintiff, criminal defense, and also some civil rights, mainly in federal court. Those are lawsuits under a federal statute against the ones I handle are primarily against police officers, jails, and penitentiaries and their employees. I went to the University of Virginia undergraduate. That was back in 1967 to 71. I graduated and then came back to Kentucky and went to the University of Louisville School of Law, and from 1971 to 1974 when I graduated. And then I had to go to armor school at Fort Knox, which doesn't qualify me for the practice of law at all, but I just thought I'd throw that in. Emily, you just call me Lynn, and I'll call you Emily if that's
Sure.
okay. And as I said to our audience, we're going to talk about driving under the influence of alcohol today. Do you handle those types of cases?
Absolutely, yes. And there's a lot of them here in McCracken County. DUI cases, driving on a DUI suspended license, driving on a suspended license, and they're all handled in a specific court, DUI court, which right now is being handled by Judge Hollowell, Chris Hollowell.
And because of what we call jurisdiction, I believe that most DUI cases locally here are handled in the McCracken District Court as opposed to the Circuit Court. Is that correct?
Yes, that's correct. As long as it's a first, second, or third offense within a 5-year period, it's handled in our district court because it's considered a misdemeanor or a traffic violation. And that's because it carries a year or less in jail.
And then if you have a fourth offense, that becomes a felony, and Class D felony, I believe, potential penalty of 1 to 5 years in the state penitentiary. And the circuit court, of course, has jurisdiction over felony offenses. So or another word for that's authority. So one of our 2 circuit judges would handle a DUI if it was a felony.
That's correct. Also, if you get caught driving on a DUI suspended license a second time within a 5-year period, or your DUI while you're driving on a suspended license multiple times, you can also, it will be a felony, and that would be handled in our circuit court.
Now, who are our 2 district judges right now that handle DUI cases when they're misdemeanors?
Judge Kitchen, Judge Tony Kitchen, and Judge Chris Hollowell are our current district court judges who would handle our misdemeanor cases.
And I believe they rotate, I guess so they don't get bored, maybe, I don't know, or it's just the procedure, but 1 year Judge Kitchen will have DUI, and then the next year Judge Hollowell will have. Is that correct?
Yes, that's correct. Right now it's Judge Chris Hollowell. Then after 2008 and 2009, if the procedure goes as it is now, it'll be Judge Kitchen.
Let's turn to some subjects concerning, well, or sort of sub-subjects, if you would, concerning DUI cases that are kind of interesting. One is the breathalyzer. And everybody's heard of a breathalyzer, and we talk about, you know, what did you blow? How is that important, and can you explain how that fits into a charge of DUI?
Sure. When someone is pulled over or stopped for a DUI, they're almost always asked to take a breathalyzer on the side of the road. That's called a portable breath test, a PBT machine. Those, as our statute is currently written, in fact, as of October of 2000, those are not admissible. However, they're just used by police to determine if there's probable cause.
Now,
So,
what do you mean not admissible?
well, that's a good question. When an officer stops you on the side of the road, a PBT can only be used to determine if there's probable cause to arrest you. That cannot be used to convict you. A breathalyzer and toxalyzer test will also be given to you at a police station, or at a jail. And at the jail, that's what's going to come into evidence against you. And if it's a .08 or higher, then that can come in to determine if you're guilty of a DUI. An officer may also ask you to take a blood or a urine test, and he has the preference of which 3 of those to use to determine your guilt or your innocence. But that portable breath test on the side of the road, that never comes in before a jury as evidence against you. It's just used to determine the probable cause to arrest you. And that's what I mean by admissible.
All right. But what if, like a case I had, the PBT, portable or preliminary breath test on the side of the road, helped my client because it showed that he was under the level that is required in order to convict?
That's another really good question. I don't think that's been completely decided yet. And I think that would probably be a case-by-case decision from a judge. But based upon the statute itself, I believe that it does not come in. The statute says that a portable breath test is not admissible for any reason, if you read it, and I think that it does not come in for any reason. Now, as a defense attorney, if it helped my client, I would make an argument that it should be able to come in as exculpatory evidence, which means evidence that went to my client's innocence, and would come in for a reason outside the statute, which gets kind of difficult and hard to understand. But I would argue it came in for a reason other than to show, other than the statute itself, a reason to show my client's innocence. Because what can often happen in a DUI case is that someone can get stopped, and at the time of the driving, the BA may be different than it would be at the time you get back to the police station and actually take that breathalyzer at the station. For instance, your BA might be a .05 at the time of the stop when you take that portable breath test, but by the time you get to the police station, drinks that you have earlier may be in your system, and so your BA may, at that time, maybe .07, .08, depending on what you had to drink. So that prior portable breath test may be what we call exculpatory, may be evidence to help you acquit your client, and so you may need to use that to help in your defense, and that may be an argument to help you get that portable breath test in.
Now, I tried to get one of those portables in, and the judge wouldn't let me. It was in a different county some time back because the statute doesn't provide for any exceptions. It just says that it's not admissible at trial. Didn't seem very fair to me that it should not be admissible at trial if it was usable for the purpose of probable cause, so that the police officer could have a justification for his arrest. What do you think about that?
I agree that the statute does say it's not admissible for any purpose. And the fact that an officer can use it to arrest someone, probable cause is a low standard. And I do agree with the judge that it does say for all purposes. I disagree that we should be able to get it in for exculpatory purposes. We should be able to use it if it helps our defense, because an officer is using it to arrest our client. They're using it to hurt us or to hurt our clients. So if there's a way that it helps our clients, I believe we should be able to get it in. But I think under the language of the statute, it's difficult to get it in.
Well, and I have read some of the company's directions, depends on the brand of portable breathalyzer used at the scene, but I believe the one that has been used a lot around here requires a wait of 15 seconds before using it after you've turned it on and
Right.
let it warm up.
I think it may be 15 minutes, 15 to 20
Did I say
minutes.
15
Right.
seconds?
Mm-hmm.
Yeah, I stand corrected. It's 15 minutes. I don't know where I got the seconds. But anyway, but you know, when I look at these arrests that I've been involved with as far as defending, it seems to me that the officers don't wait 15 minutes at the scene before they administer that portable. So it doesn't seem fair that it should even be allowed for the purpose of probable cause, because maybe that the mouth is contaminated by having a pocket of alcohol that hasn't cleared, you know, say 3 or 4 minutes after the stop, or the person may have contaminated the sample by smoking or something else.
Correct, yeah. And I think that that's being justified by officers these days by saying it's not admissible, so it doesn't matter. But yet our clients are getting arrested. And you know, one thing that's kind of scary is once you get arrested for a DUI, it really doesn't matter what that breathalyzer test says. You're going to jail. So that's a good point, because we're having PBT tests that are leading to our client's arrest, but then breathalyzers that may come back under a .08, blood tests that we don't know the answer to for weeks or months, but yet clients that are going to jail for it.
All right, let's shift gears a little bit. Let's say that a client comes into your office. The client is charged with DUI first offense. All right, what is the prosecutor going to have to prove to a jury beyond a reasonable doubt before there can be a conviction on that charge?
Well, there's two ways to convict somebody for a DUI. They're either going to have to prove that they're under the influence beyond a reasonable doubt, or they have a presumption that they have a .08 or higher BA. The .08 higher BA is easier to prove because you've got that number, and unfortunately it's easy for jurors to hang their hat on a number and convict somebody. There are ways to overcome a presumption. You can prove that the defense attorney can prove the machine wasn't working right. Maybe it was messed up that day. Maybe there was something in your client's mouth that caused it to be higher. But that's the easier way to prove a DUI. The other way is maybe you don't have the number. Maybe the number was lower than a .08. Maybe there was a refusal. And then you have to prove that they were under the influence of alcohol, drugs, some kind of substance that caused you to be under the influence. A defense attorney or a prosecutor is not allowed to define under the influence in the state of Kentucky. So it's what you as a juror believe is under the influence. And that pretty much is just defined by what a juror believes is under the influence. You may have these field sobriety tests, and most people have seen those where you hold one leg up for 30 seconds or walk a line. The truth of the matter is that nobody can do those perfectly, in my opinion, and prosecutor wants you to believe it's possible, but it's just not.
All right, what if the charge against your client is that he or she has a blood alcohol level of .08 or above, and that there was a breathalyzer administered and taken by the defendant accused, and it was 3 hours after the person was seen last driving. In other words, let's say 3 hours after the police officer stopped him or her.
I think that breathalyzer test can come into evidence and the jury can know about it, but you will not be presumed to have a .08 or higher BA. And the reason is because the law in the state of Kentucky says that you have to have operated a motor vehicle within 2 hours of the time that you take that test.
Are you saying the level can come into evidence?
I think the number can come into evidence. There may be some prosecutors that don't put that number into evidence, and there may be some people that disagree with me on that. But I think that the number can come in, and you just don't get that DUI instruction that says that it's presumed to be 08 or higher. The jury can just know about it, but you don't get that presumed DUI instruction.
All right, I think I see what you mean. I'm not totally sure we agree on that. I'm not totally sure we disagree.
Yeah, I think they have to prove your client to be under the influence. There's not a .08 or higher presumption that your client is under the influence. But I don't think there's anything that excludes the number. You just don't get that presumed under the influence jury instruction.
All right, so so the jury is just looking at this as another piece of evidence that might consider in deciding whether the person was under the influence, as opposed to deciding whether presumptively he or she had blown a .08 or higher.
Right, and really the number doesn't have much value because the number comes so much later than the time that you operated the vehicle.
Now, it's never seemed fair to me that you can introduce into evidence against somebody a breathalyzer or a blood alcohol level, either one, of 0.08 or higher, when it may be an hour and 45 minutes, some length of time since they've last driven a vehicle when that test is administered and when that particular level is determined. What do you think about that?
I agree with you, but our state legislature doesn't, and they passed a statute. There is a statute that states that if you were operating a vehicle within 2 hours of cessation of operating the motor vehicle, that number can come in and be presumed to be the number that you had when you were operating it. Now,
well, do you argue to a jury when you try one of these cases that, hey, the deal here is that a person is charged with driving or being in physical control of a motor vehicle while under the influence, and so the number that's important here is at the time that they were last driving.
Absolutely, and you can argue that, and there's case law that says you can argue that. That's just a presumption, but you can overcome that presumption by arguing that at the time he drove, his BA might have been higher, might have been lower. Of course, we want to always argue that it was lower, and that's what I was talking about earlier, that rising blood alcohol. You might have had a drink, at 8 o'clock, but you got stopped at 8:15, so that drink wouldn't have been in your system for 45 minutes, until 45 minutes later when you actually took the breathalyzer test. So what matters and what the jury has to convict you of is your BA at the time you're operating. All that the law says is that that number gets to come in if it was within 2 hours of the time that you operated under a per se jury instruction.
So this kind of works like a curve. After you start drinking, your alcohol level is going to go up. At some point it's going to peak, and then when you stop drinking, at some point, whenever you stop drinking, it's going to come down again.
And it's going to be different for every person based on their body weight.
So it could peak and be, let's say, a 0.09 at the time you take the breathalyzer or have the blood drawn, and it could have been a 0.05
right.
At the time that you were driving.
Right, and it could operate exactly the opposite way.
All right, is there some way for the poor old defendant, if he has some extra money laying around, to try to prove that to a jury?
There are experts that can come in and testify. They can look at your body weight, they can look at what you had to drink, they can look at what you had to eat, they can look at how much you had to drink, and they can come in and testify in court what they believe your breathalyzer would have been at the exact time you would have stopped.
But those experts cost a lot of money.
Absolutely. Don't they? Every expert costs money.
Give me an idea of what we're talking about, several $1,000s?
Maybe $1,000 to $3,000, depending on who you have, where they come from.
All right. Now, what happens to the person that is found guilty or pleads guilty to DUI first offense? In other words, what are the potential penalties for that offense?
Well, the potential penalty for first offense DUI would be up to 30 days in jail, 30 to 120-day license suspension, a fine, and a $325 service fee. You have to have alcohol education classes. But what usually happens to someone who has a first offense DUI is if they've never been in trouble before and they have a BA that's under a 0.18, they're not going to do any jail time. They're going to lose their license for 30 to 60 days. They're going to have what's called some conditionally discharged jail time, which means as long as they don't get any trouble over the next 2 years, they won't go to jail, and they're going to have to do alcohol education classes to get their license back. If you have a BA that's over a 0.18 on a first offense DUI, then you will serve usually 4 days in jail.
All right, a lot of people are interested in this question about the hardship driver's license. Is there any limitation on that, or can you get a hardship license every time you get charged with DUI? So you get charged with first offense, and then later on you get another one, second, another one, third. Is that hardship license available each time?
I think there's a lot of confusion on hardship license, and the first thing people need to know is that the only time you can get a hardship license is when you're charged with a DUI. A lot of people get suspended license for other reasons, and you can't get a hardship license for those reasons. When you get charged with a DUI, you can only get a hardship license after you've been convicted. A lot of times your license are suspended while the charge is pending, and you cannot get a hardship during that period. The other thing people need to know about hardship license is you are going to lose your license for a period of time on any DUI conviction, and that time period is going to be for the mandatory minimum period, and then you're eligible for a hardship. So for a first offense DUI, you're going to lose your license for 30 days. No lawyer can get you out of it. No judge can get you out of it. The Department of Transportation is going to take your license for 30 days. Then, if you lose it for longer than that, because you can lose it for up to 120, you could get a hardship. For a second offense, you're going to lose your license for a year. There's no way out of it. If you don't get your license back after that year, you could get a hardship for up to 18 months.
And you have to complete the drug and
Alcohol,
alcohol program, am I correct, before you can get that license back?
Before you can get your regular license back.
That's what I mean.
Yeah.
So what happens is if I have a DUI second and my license is taken for a year and I'm ordered to go to the drug and alcohol program and I don't complete it within that year, my license could remain suspended beyond the year.
Exactly. And if you want to, between that 12 to 18 month period, while you're continuing to try to get your license back, you could get a hardship. So it's really limited when you can get a hardship. That would be the time you could get a hardship.
A lot of people plead guilty to DUIs, don't they?
Sure. Most people probably do.
And you're around the courts. I see you over there, and I get over there to the DUI court occasionally, and I see a lot of people plead guilty without a lawyer.
Right.
And hear that, well, why pay a lawyer if you're going to go over and plead guilty? What's the justification for getting a lawyer on a DUI, say, first offense?
Well, a lot of times there are things in a DUI case that you're never even going to see if you don't have a lawyer. First of all, there's usually a videotape, especially in McCracken County. You're never going to see that videotape probably if you don't hire a lawyer.
Well, let's stop just a minute. That's a new one. You haven't mentioned that before, and neither did I. Videotape, what kind of videotape and where does it come from?
The officer cruiser is usually equipped with video equipment and audio equipment. And you can file an agreed order, your attorney and the county attorney, to get that videotape, and then you can watch it with your lawyer. You can find out a lot of things from that tape. You can find out if your implied consent rights were read. What I mean by that is the law requires that you are read an implied consent card. That tells you you have the right to call an attorney before you take this breathalyzer blood or urine test that we're talking about. It tells you that you're told certain things like if you refuse to take this test, you could be subject to twice the mandatory minimum jail time. Standard rights that have to be read to you.
All right, am I correct that if these implied consent rights, and those are different from the Miranda warnings?
Yes.
Right, but if those are not read, properly and at the proper location, so forth, then the lawyer can move to exclude or keep out the breathalyzer result or the blood alcohol result.
And
did I say blood alcohol? Yeah.
And right, and not only can the lawyer file that, the judge should keep it out if they're not read.
All right, I was looking at the cameraman. I think we've got about 4 minutes
Okay.
left, if I can see him all right. So anyway, you were going on, and when I interrupt you, about why it's a lawyer's justified even
Right.
for a DUI first offense.
Another thing is you have a right to an independent blood test after you take whatever test the officer wants you to take. If you don't get that right to an independent test, your test should be thrown out. On a second and third offense DUI, something else is you should review your prior DUIs to make sure that they're valid, and a lawyer can do that for you. You never know for sure what you're going to turn up. You may not turn up anything, but at least you know you've tried everything you can to see if you can find something in this case.
Now, I've mentioned first, second, third offenses, and then we said fourth offense, DUI was felony. How are those determined? Is it just in the chronological order that, 10 years ago I got a DUI, and then, yesterday I got another one? Does that make it a second offense under the law?
It has to be, DUIs only stay on your record for 5 years, and it's from the date of the offense. So if you got a DUI January of 2000, then it would only stay on your record until January of 2005. And it's from the date that you committed the offense, not from the date that you were convicted of the offense.
All right. Well, we're just about out of time, I think. Have a couple more minutes. One of the things that has always been interesting to me is where the police officer has to give these implied consent rights. And I remember I had a case back a while ago where he gave it in the parking lot of the hospital in the police cruiser while he was sitting in the front seat and the defendant was sitting in the back. And I argued that that wasn't good enough, that he had to give it in the hospital, because I think the statute says for a blood alcohol at the hospital. What do you say about that?
Well, the statute definitely says at the testing site, and every judge I've ever seen so far has allowed it to be given in the parking lot of the hospital. That seems to be happening all the time.
And what about when you say testing site, is that a similar situation for the breathalyzer?
I've always seen it be given in the BA room. I haven't had it actually come up maybe where it's given out in the Sally port of the jail. Places I have seen it where it has been suppressed if it's given on the side of the road. That was happening a lot when the statute first got changed in October of 2000. They were giving it on the side of the road. People say, I don't want it. One thing I have seen that's come up a lot is people will refuse to take a breathalyzer. They'll ask them to give blood, and they won't take them to the hospital to give blood, and they count that as a refusal. And that they will suppress that, because you do have to at least take them to the parking lot. Probably not close enough, but judges are allowing it.
We're out of time. I want to thank you for being here today with me, and I want to thank our audience for tuning in to watch Driving Under the Influence of Alcohol. And, we like to make a fee every now and then, but the best bet is don't drink and drive. Thank you, and we hope that you have a good day.